Good morning. I'm Jane Fielding and I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome you to this, the first of our annual series of webinars in which we take a look at the year ahead, 2022, to bring you up to speed on some of the topical employment law developments that we think you need to be aware of. Our topic today is whistleblowing. And whether you call it speaking up, protected disclosures, blowing the whistle, there is an increasing need for employers to be aware of their obligations and also the opportunities that having a proper approach to speaking up can give you to help improve your organisation. It's also of increasing importance because in our experience, employees and workers are increasingly aware of their rights in the workplace. There's an increasingly complex web of legislation and regulation that employers have to deal with depending on their sector. And we've also seen an increasing willingness on the part of employees and workers to speak up and speak out about issues that concern them. So this isn't going away, and we also have a new European directive which employers need to understand the impact on their business of. And so there's lots to get to grips with and lots to need to be aware of for 2022 and beyond. And judging by the 435 of you that are registered for today, we think we've struck a chord here. So our speaker today is Simon Stephen, one of the legal directors in our team, who specialises in the area of whistleblowing. And he also leads for us on the S bit of our ESG initiative, so environmental, social and governance initiatives, which we're doing a lot of work with clients on. And there's a natural overlap with whistleblowing there, as you'll be aware. So Simon is going to talk for about 25 minutes, and then we'll have time for questions at the end before we close at 11:40 and let you get on with the rest of your day. If we don't get to your question, we may not have time for all of them. Please don't worry, we will follow up afterwards on all of them, so it will not go unanswered. If you do want to ask a question, then please use the Q&A function, which is what we have enabled today. If you're not familiar with Zoom, it's at the bottom of the screen in the middle. If you've got a technical question, can you also use that? Hopefully everything will go smoothly, but if not, drop your question in there, and Lucy Strong, who's helping us on the tech side today, will do her best to get that sorted for you during the webinar as quickly as possible. At the end, we will be circulating a feedback form by email. I'll mention it again before we close, but it only takes a couple of minutes to complete. We'd be really grateful if you would take the time to do that so we can use your thoughts to help shape future webinars. So I will now go on mute and hand over to Simon.
Thank you, Jane, for that introduction. And without any further ado, I'll get cracking with the agenda. So thank you again for joining everyone today. There are three areas I wanted to crunch through today in the allotted time. I could talk about whistleblowing all day, but you'll be grateful to know I'm not going to. The first is just talk through legal developments from last year and talk through what I think are the two key battlegrounds for whistleblowing claims. Also then want to look at the impact of the EU directive on UK companies, and then we'll touch on potential future developments as well. And all of these, the aim is to kind of give you a broad brush review approach of where whistleblowing is to help you kind of future proof and future plan with how you are progressing things this year. So before we get into that, though, just a reminder about why it matters. James already touched on the ESG point, but at the heart of whistleblowing, it is actually meant to be a good thing, and I think we can forget about this. At the heart of it, it enables us to investigate issues. I've got my good friend Sherlock Holmes, whose books I'm quite a fan of. Insert your own favourite detective in there, but it helps you investigate things to find out root causes and take remedial action, hopefully to avoid disasters such as the ferry disaster pictured up there on the left. You know, truly horrific things have happened where people have either not been able to speak up or they've spoken up and haven't been listened to. Whistleblowing is, as Jane mentioned, also a fundamental part of ESG. It underpins everything that sits under governance under that the G there. If you don't have whistleblowing built into your compliance and governance framework, then I think you're missing a trick. Excuse me. If my voice doesn't hold, apologies, I'm recovering from COVID, but we'll get there through it as we go. But linked to the S as well as the impacts on people. Whistleblowing and speak up cultures, there are plenty of statistics out there. if you have a good culture which enables people to speak up in any form, then that's going to help your employee engagement. It's going to help employee well-being, which reduces absence, helps mental health, and improves productivity as well. And that then goes back into society and the company's reputation, which is again part of the S under ESG. And lastly, but not least, it matters because the regulators tell us it does. Whistleblowing is a really easy stick for regulators and stakeholders to use to kind of force the compliance, risk and control agenda. I've put the FCA up there as kind of one I feature, I deal mostly with, but you see it through all the regulators, including corporate governance codes and shareholder interests as well. But it also matters from a kind of legal risk and cost point of view. At this point, I'm just going to ask Lucy to put up on the screen a poll just to highlight the impact that getting it wrong can be. So Lucy, if we could have the poll. Hopefully everyone can see the poll there with the question 3 answers. What is the highest reported reward in the employment tribunals for a whistleblowing case? Just give it a few seconds for that. Okay, Lucy, if we could then have the answers back up and we'll just take a view, see how we get people up from there. Yep, so a fairly mixed bag. Most people have unfortunately pitched it too low. It is in fact over £2 million. That was the case of Osborne and Timms a few years ago. And that was a detriment case, but that included loss of earnings, injury to feelings, and a number of other different aspects. Wanted to do that, not least to make sure you're listening, but also to just drive home just how important this can be from a legal employment tribunal point of view. Okay, so then coming on to the first bit, an update on the legal context. The first thing I think just is really important with whistleblowing is to go back to the basics and have a reminder. As you'll see through the cases, if you don't do this, even the tribunals don't do it, they get things wrong. So just as a reminder up on the slide there, what we're talking about when we're talking about whistleblowing in the legal context is a qualifying disclosure. That's a qualifying protected disclosure. First of all, it's where a worker, and notice that's much wider than employee. So that includes partners in an LLP, includes judges, it's very broad, who discloses information. And one of the cases we'll look at, we'll talk through a bit more about what information is, but it has to be something tangible, something to kind of to hang a hook on. But that disclosure has to be with a reasonable belief that the disclosure is in the public interest. And again, we'll talk through one of the cases last year, which helps show the tribunal's approach to that, but also has to have a reasonable belief that the disclosure shows or tend to show a relevant failure. And I'm supposing a basic knowledge of whistleblowing in this talk, but as a reminder, a relevant failure is that there are concerns relating to breaches of health and safety, miscarriages of justice, criminal offences, damages to the environment, breaches of legal obligations, which is in effect a catch-all, and the deliberate concealment of any of the above. And the key thing in those bits really to take from that is that the reasonable belief has to be there as well. And I flag reasonable belief because that isn't your belief and it's not my belief. It's the belief of the individual making it. So do they have a belief that it's in the public interest or it shows a relevant failure? And is that belief reasonable? They are things that need to be explored. And it doesn't matter if you know that they're wrong, but if they think that they are and that belief is reasonable, then the tribunal will say it's okay. So that's the legal context to bear in mind. So yes, the second point of legal context, moving on from the content, is what I kind of call the consequence, and there we have dismissal and detriment. So once you jump through those loopholes and somebody has been found to have made a qualifying disclosure, they are then protected from being unfairly dismissed and subjected to a detriment. And I've flagged up here these two because the test is very different for each one, and we'll see the problems that can cause later. But you are protected from being unfairly dismissed because you're automatically unfairly dismissed if the reason or the principal reason is that an individual has made a protected disclosure. So that's very kind of quite a high hurdle, really. It's, what is the reason behind the dismissal? However, an individual is subject to a detriment if there's any act or failure to act on the ground that they have made a protected disclosure. And that's a much lower hurdle. And the cases the tribunals have held that on the ground effectively means that the disclosure has materially influenced the act or failure to act. And that influence just has to be more than trivial. So it's actually a very low hurdle. But we'll see the problems that can cause from that. So moving on to the next slide. Oh, I feel like Professor Whitty. Um, there are therefore I've bucketed this into two key legal areas where I think we really need to focus on when dealing with whistleblowing. And I think the problems arise when people don't do this and tribunals don't do it. We don't follow this kind of forensic analytical approach because whistleblowing, people don't submit a whistleblowing kind of issue, tend to, breaking it down, following all the technical statutory tests. Whistleblowing occurs over time, a number of different disclosures, and there's a lot of emotion and stuff involved as well. So it can be quite quickly caught up in what I call a lot of fog, which distracts from actually how the law works. So I think it's very important to focus on, first of all, what is the content and what is the consequence. And I'm going to look at now, if we can move on to the next slide, the key legal updates in those two areas. First of all, looking at content, kind of what is disclosed, looking at the case of Martin and the London Borough of Southwark, and there's a school involved in there as well from 2021. And in the transcript that we provide afterwards, I'll make sure all the case references are in there for you. But what this case made very clear is that tribunals should take a very structured approach to apply the necessary conditions, those conditions that we applied, that I kind of went through earlier on. What happened in Martin was that Martin was a teacher and he sent an email, he sent 4 or 5 emails, but starting with his head teacher and ending up with the governors, raising concerns that the hours worked by teachers, himself and others, were in breach of the kind of required guidelines and limits. And he started phrasing this in lines of, these are my calculations, we're in excess of this, I must have missed something, can we have a chat? And ultimately what the tribunal did was they didn't go through kind of that forensic analysis of what the information was, did he have a reasonable belief, etc. They really looked at that and just said, well, he's not really raising anything, he is making an inquiry. He is inquiring about what is happening. But they didn't go through that approach of breaking down the requirements of the Employment Rights Act. So the Employment Appeals Tribunal dismissed the judgment in a pretty damning judgment themselves. And they said what the tribunal should have done was broken down each limb and then done an analysis of whether he met the requirements from that. And they said in particular in relation to information, what they hadn't done was had a look specifically about what he was saying and whether or not it contained sufficient factual content and detail to demonstrate that actually wrongdoing, etc., had happened. So, despite the fact that he'd raised it in the form of an inquiry, it could actually still be information. And I think that's a really important thing for us to take away, and particularly those who deal with whistleblowing on a daily basis, because quite often these issues start with somebody questioning something. I've noticed that ABC is happening. Is this right? And you're right, people might well think, actually, well, that's not raising a whistleblowing, that's just a question. But I think this is a really good example as a question can still contain enough information. And if it's still then linked to somebody having a reasonable belief that it shows wrongdoing and a reasonable belief that it's in the public interest, a question still could meet the definition to be a protected disclosure, which could then have those consequences we looked at. So the learning point here is to always break down alleged disclosures, and that's when you're dealing with the claim yourself, when you're advising on one, looking at what it actually is, breaking it down. But I think also when looking at things that come up in whistleblowing investigations or grievances or complaints, or indeed even if someone's just being a bit difficult, which is where training for managers and staff and having a speak up culture is so key. So people are aware and able to take a step back and say, oh, hang on a minute, I can see where this one might end up. So I'm just going to take a step back. Okay, so then moving on to the next slide on content, which is the public interest. And the case I wanted to talk through here was the case of Dobby and Felton, trading as Felton solicitors. Dobby was a legal consultant, not a legal elf, as I have been called fairly recently. But this was a case where he had been working with Felton for a number of years, working on a big litigation case. And he raised concerns that a client, a really important client for the company, for the solicitors, had been overcharged. that other people's kind of hours were being inflated, overcharged, etc. He raised these kind of really in the context of if they were going to go for a cost assessment, then he didn't think that they would be very successful in getting those costs back because of overcharging. That was the initial kind of context of how he raised them. And what the employment tribunal kind of said in this context was, yes, he had a reasonable, yes, he'd disclosed information, kind of how he had phrased it, made it clear that he did have these concerns, that there was a concern that it was overcharging. Yes, he had a reasonable belief that that they showed wrongdoing because there's legal obligations, regulatory requirements. So that was fine. But where where Mr. Dobby failed was in relation to the public interest. The tribunal said they didn't think that he'd raised it in the public interest. At the time that he raised it, they didn't think he has a reasonable belief that it was in the public interest. They said actually what it was a private issue for the firm as to whether it would be able to reclaim its costs back through the cost assessment. The EAT disagreed with this and said actually what the tribunal hadn't done was they hadn't properly analysed the public interest. They hadn't forensically gone through whether or not he had a reasonable belief that it was in the public interest. And importantly, the tribunal didn't seem to have looked at the relevant case law, in particular the case of Chesterton and Nur Mohammed, which is a Court of Appeal case. And EAT looked at that and said there are four things really to consider when looking at whether something's in the public interest. The first is whether the number of people whose interest the disclosure served. You have to look at how many there are. The more there are, the more likely it is to be in the public interest. But still, the point is one can be enough. You also have to look at the nature of the interest affected and the extent of how it is affected. So looking at kind of everything in the round and all the circumstances. And these were things that the tribunal didn't do. They hadn't kind of broken it down or referred back to these. You then also have to look at the nature of the wrongdoing, and particularly if it was deliberate. So if there was something deliberate, if people are deliberately cooking the books, then that's going to be more likely to be in the public interest than not. You also then have to look at the identity of the wrongdoer as well. So, who is it? What role do they play? Where do they sit in society? So they're the things to consider, which the tribunal didn't. And the EAT, when looking at that in the context of what Mr. Dobby had said actually it's not for them to decide because they remitted it back. That made it very clear what they thought. And I think they're looking at the nature of the wrongdoing. It's potential regulatory breaches by a firm of solicitors. And so regulatory breaches by the very nature of them are something which is of wider interest. And then you look at the identity of the wrongdoer as well, firm of solicitors, and looking at that firm of solicitors, we are subject to high requirements, honesty and integrity. So the EAT gave that all pretty short shrift and booted it back down to another tribunal to consider. But I think that's another really good example of how you can look at something on the face of it and just think, well, that's just a personal gripe. Or that's just a private motive. But actually, the public interest test is a lot wider than that. And there are so many things you have to take into account and look at it. And it's going to be the tribunal ultimately who decide. Okay, so then moving on to the next slide. So moving away from the content bucket, moving into the consequence bucket. So I said it shows what I hope to show from those cases, that the tribunal struggles with whistleblowing as well, kind of getting to grips with it. And a lot of that is if it isn't presented to them in a neatly packaged way, setting everything out, distilling all the emotion, etc. And where that then causes problems is the issue in kind of the consequences, dismissal and detriment, and particularly what I call the battleground of causation. Because even if you've got the content made, even if somebody has made a protected disclosure, they've still got to then make that causative link to either the dismissal and the detriment. And the following three cases, I think, give really good examples about how that works in practice. So first of all, Kong and Golf International. Here, there was an issue where somebody senior raised issues around the compliance of products that have been made. So actually, were these products that were being kind of put out, were they kind of legal, were they compliant, did they meet regulatory practices, etc. So Mrs. Kong was raising these concerns. For want of a better phrase, they ended a spat internally about whether they actually did kind of do that. And it culminated in Kong being dismissed. Now, she had made disclosures, And of course, everyone was unhappy about that because they were challenging things. But ultimately, what the tribunal said that you could separate the dismissal from the concerns raised. So you could drive a wedge between the two. She had raised concerns, yes, and of course that fed into the dismissal because, in a way, but because she was dismissed for how she acted rather than the reason being the dismissals themselves, then it wasn't an automatic unfair dismissal. So I think a clear case showing, while controversial, maybe showing that it's really key to separate the reasons for a dismissal from any disclosures where possible. In the case of Secure Care UK Limited and Mott is another good example as well. But it also shows the importance of being very clear as to what is accepted to be disclosures and what isn't, and what is the causative link between them as well. Because here there were 3 out of 9 disclosures which were found to qualify for protection. And what the here, Secure Care UK Limited, they provide transport services to the NHS, particularly for mental health patients. Mr. Mott was a senior logistics manager, had control of control room, etc. And he raised a number of disclosures about resource, about the ability to meet requirements. And there was one as well where he felt that he was being effectively told to lie to a client about cover being made available in breach of regulatory requirements. He was then made redundant together with 2 other people. The tribunal, and he was claiming that dismissal was by reason of his protected disclosure, and he claimed detriments in the run up to that process as well, including being put at risk of redundancy. The tribunal said, found, as I said, 3 out of 9 disclosures. They then found that he had been subject to detriments and he had been automatically unfairly dismissed. But they applied the wrong test. And they hadn't really helped themselves by breaking down the tests, etc., to be applied. But whilst they had referred themselves to the right test, what was clear is that they had actually effectively said that the protected disclosures had influenced the decision to dismiss, and therefore is automatically unfair. But actually, what they should have applied is that test is the reason, and they thought it was clear that the reason was that actually it's linked to the reason was him being at risk of redundancy, not the disclosures. And they also said that the tribunal hadn't made it clear which of the disclosures was actually the ones which were linked to the dismissal, which they thought it was. They bucketed them all up. So whilst finding that there were 3 disclosures that qualified, they still referred to them kind of in the general as 9 and talked about them all as a whole. So it's really important there to separate which disclosures you're talking about when talking about kind of the consequences. And I think the learning point for kind of employers there is also making it absolutely clear when you're dealing with people what the core reason is, making it clear that if it's redundancy, yes, we know he's made noises and there's all these things in the background, but having clear objective reasons behind it. Okay, if we can move on to the final slide in the consequence. In relation to detriment, and I just thought I'd just flag up there the point that the error the tribunal made in Secure Care UK Limited and Mott is that they use the test for detriment, which is to materially influence, which is very different. And the next case I wanted to run through, Oxford Said Business School and Heslop, I think is a case which really clearly gives an example about how that should work in practice when tribunals are dealing with it. And here Heslop was a senior person working for Oxford Said Business School and raised a number of concerns about the products that they were having and whether they were in compliance with government contracts. And indeed, the most famous one, I think that's reported in the Times, etc., was that one of the courses that they were producing, and I think charging around £1 million, they just cut and paste from other courses. So kind of weren't doing what they should have done. There were a number of these were accepted to be protected disclosures. She kind of raised these, they weren't really dealt with, but at the same time, or around the time she had raised these, a number of people were making complaints about her management, about her leadership, which were then picked up on by the business school and then taken to her and said, oh, we've got all these complaints, we're going to be taking action, we're going to be doing these things. She then resigned effectively in response, well, she did resign in response to her treatment, alleging that that treatment was a fundamental breach of contract, and that reason was because she had made protected disclosures. So she's saying, I'm resigning because of your treatment, and your treatment was because I had made protected disclosures. What the tribunal said was actually applying the test correctly, The steps taken up to her resignation, which was the dismissal, were indeed detriments on the ground of that she had made protected disclosures. The treatment of her in relation to managing the complaints and managing the disclosures she has made, which they didn't do, they breached their cascade of practice and treated her pretty badly. Their decisions there, including failing to act, were materially influenced by her making the protected disclosures. So she was subjected to detriments in the run up to the resignation. But actually, the reason that they kind of met with her and told her that she was going to be effectively disciplined, all this kind of stuff. So the reason on the back of which she resigned was not because of the protected disclosures. It wasn't by reason of, it was by reason of the complaints that had been made against her. So a fine line, and that was something which the tribunal decided and the EAT upheld. So again, I think it shows a really good example of how things should work in practice and how important it is to understand how those tests work, but also understand how when dealing with whistleblowers, it's very important to separate any action that may be taken from the actual kind of disclosures themselves. Okay, so moving on to the next slide, now I wanted to touch on the impact of the EU directive. As Jane said, this is kind of pretty big impact now for EU member states kind of coming through. Obviously, we're not part of the EU, we're not bound by the directive, and we're not implementing it here in the UK, but I think it still does have a big impact on UK businesses. For those who don't know, it was supposed to have been implemented by member states by the 17th of December 2021. I think it's fair to say that not many have done that. As of speaking, I think it's Spain, Denmark, and Portugal. Sorry, Sweden, Denmark, and Portugal who have implemented it. The others are in various stages. So you might kind of think, well, why would we worry about the EU directive if it doesn't apply to us? If we don't need to do anything. Well, I think you do need to think about it and need to start building it into your planning as to how we're dealing with whistleblowing. Because first of all, what it does, it obviously goes across the EU members states. So there should be a cohesive pattern in a way of people dealing with whistleblowing. If you've got any presence in the EU, this is going to impact you. But I think also the key things to understand is what the whistleblowing directive says, because this shows a pattern, I think, and kind of a pattern of movement. First of all, the EU directive will cover a wider category of individuals. It obviously employees, but those who are self-employed, it covers contractors, employees of contractors, subcontractors, and suppliers. So a much wider range of people are going to be caught. It also includes interesting facilitators, people who facilitate whistleblowing in the workplace. So they don't actually make whistleblowing themselves. So again, much broader sense. What we're looking at is across the EU member states, there will be a much wider category of people who will be caught. There's also a requirement to make sure that disclosures are kept as confidential as possible. Now, this is something that most policies will deal with and regulators will say so, but it's not a legal requirement in the UK. So I think that's a key point to kind of bring out as well. And there's also a requirement in the EU directive to take action within set timeframes. So first of all, you have to acknowledge the whistleblowing report within 7 days and have to provide an update within a minimum of 3 months. So very different from the UK approach, which is looking at after the horse has bolted, if you like, what is the protection available? Here is kind of putting things in at the front end. And perhaps the biggest impact is the requirement to have local internal reporting procedures, whistleblowing hotlines. Most people will have whistleblowing hotlines in place, but the directive is making it a matter of law across the EU that you have to have local internal reporting procedures. And this requirement kicks in for people, well, organizations, public and private, with 50 plus employees. If you've got between 50 and 249, you've got a couple of years kind of breathing space, but they kick in. So that's going to be quite a big change there. So moving on to the next slide, please. So what does this matter? Well, as I said, if you've got an EU presence, you're going to have to understand these local obligations when they emerge. I said the idea of the whistleblowing directive is to have a fairly uniform approach across the EU to whistleblowing, but the reality is that as and when local jurisdictions implement their laws, those laws are going to be very different. So you're going to have to be able to do that due diligence. We're doing this with a number of clients, of looking at what their obligations are in the areas where they have a presence, whatever that might be. And I think at the very least, what this is meaning is that, and we're seeing a number of clients looking at doing this now, is having an audit of whistleblowing governance on the back of what the EU whistleblowing directive says should take place. If you have an EU presence in any way, then it's important to do this audit to make sure that your governance not only complies with UK law, but across the board as well. It's also important to kind of make sure you understand what's coming in and then building in those local obligations. And one of the key things I think as part of that audit is having a review of your reporting channels, both global and local ones. Because one of the big difficulties that we're seeing with the directive is this clash between having a local reporting channel, which is what people are required to do. So if you are in France, you have a French reporting channel, and what has been customary practice before to have a global whistleblowing channel. Can you actually still have a global one? The jury's out a bit in that. Denmark have proceeded on the basis that they can, but the EU Commission have been pretty clear to say that actually you can still have a global one, but you must have a local one as well, and individuals must have the option to use the local one over the global one, which causes them big problems in how do you monitor them, how do you keep consistency, how do you monitor themes and trends. So something very much to look at with your whistleblowing providers. I think there also needs to be a review of whistleblowing policies and procedures. A number of clients again are doing this, looking to see as best they can if you have a global whistleblowing policy and procedure to make sure it builds in the EU directive where you can, but also expressly allows for local kind of amendments and changes where possible. And I think as well, something that is missed a bit is given the wider definition of people who can raise concerns under whistleblowing directive to include employees of those in the supply chain. I think it is wise then to do a review of supply chain requirements into whistleblowing governance as part of the governance of that supply chain itself, making sure that you have the requirements in there that if issues are raised, they are dealt with properly, and perhaps also that you know about them so you know what they are, particularly if they are, you know, along the lines of ethical or kind of legal concerns, to make sure that they're built in. So they're the main impacts, I think, of the EU directive and actions that need to be done now. Even if you don't have an EU presence, I think the whistleblowing directive will be used as a benchmark of where things should be, and I think it's just part of that travel. And coming on to the last slide, future proofing. In terms of future proofing and looking forward, I think it's a reminder just to keep speak up cultures and psychological safety a key part of ESG. All the points we talked about now will be part of that S and the G, and regulatory and stakeholder scrutiny is only going to get stronger using the EU whistleblowing directive, using all the kind of the lessons we've learned over the past few years to kind of enhance that carrot and stick approach, if you like. And whilst there is continued lobbying for stronger UK protection, to mirror a number of the points in the whistleblower directive and to broaden it out even wider, there is, however, no foreseeable change to UK legislation. I think it's going to come at some point. The government has clearly different priorities at the moment, but I think it's only a matter of time before we do have that. But at the moment, it's all about the culture and the continued improvement. And I think fundamentally making sure that your whistleblowing processes are a key and fundamental part of your overall risk strategy and approach to ESG. Now, my voice is well and truly going, and I've shot over time, not least for the technical issues, so I'm going to stop there and we can move on to questions.
Sure, thanks, Simon. So we've got a few, and we've got time to get through most of them, I hope. So there's one here picking up on the EU directive, actually, and the reporting channels and the relevant number of staff to trigger the obligation. It's a question: is that 50 number? Is that a global figure, or is it triggered by the number of staff in a particular country?
Well, this is a matter of debate at the moment because there's no definition in the directive, and in other directives it's very clear. It talks about kind of, you know, where those people have to kind of be based, and the current thinking is that actually that's a global figure. So rather than thinking, do I have 50 people in France? Therefore, do I need to have a whistleblowing hotline in France? It's, do I have 50 people across the UK? In which case, I need to have a whistleblowing hotline in every country where I have a base. That's the current thinking.
Yeah. Well, a member state where you've got a.
Sorry, yeah.
Yeah. And then you might choose to do it here, as you say. So, and another question on the EU directive: is it only breaches of EU law that this is meant to be sort of flushing out, or does it also cover domestic law in a member state that doesn't derive from the EU? So, something that the country has decided to put in place, but isn't required at EU level.
Yeah, so the EU directive itself is concerned with EU law, and it has a set kind of list, if you like, a kind of EU law that covers like public procurement, financial services, transport safety, protection of the environment, things like that. So that's what the directive says, but it's up to individual states to kind of gold plate if they like. So individual member states may well include their own domestic law kind of in there, which is one of the another one of the key reasons why it's always important to make sure we understand what those member states have actually implemented as part of their law. But the directive itself is based on breaches of EU law.
Yeah. Okay. So moving away from the directive, then there's a question here about damages. So someone's saying they thought there was a case on the point about whether you can claim damages for dismissal, that whether dismissal flows from a detriment.
Yes, there is. And in fact, the Oxford Side Business School case is kind of is one of the only ones I'm really aware of that has applied that as well. But there was the case at Osborough and Timms many years ago where somebody couldn't claim dismissal because of their non-executive director, etc. So because of their stature, but you can't claim detriment as a dismissal. So you can't say, oh, I've been dismissed and that is a detriment. They're very separate. But what the Osborough case and where kind of, what is now accepted law is that if you've been subjected to a dismissal and a consequence of that, if you've been subjected to a detriment, the consequence of that is a dismissal and there is loss that flows from that, then it is possible for you to claim damages that flow then from the detriment to include the fact you're no longer employed. And in the Oxford Side Business School case, that is what the claimant successfully argued, and there was a remedy hearing. I think it was, I think that's under appeal as well. But she was awarded 1.5 million in that because of the impact on her future career from having raised disclosures from which is subjected to a detriment, which then led to her being dismissed, even though the dismissal wasn't by a principal reason of them. So it's very complicated, but hopefully I've made that a bit clearer.
Yeah, well, no, and it just shows the breadth of the protection, isn't it? There's a tendency to broaden it where possible rather than sort of use a legal technicality.
Yeah.
We've got time for one very quick final question and answer. You said the Kong case, you referred to it as controversial. Do you think it was actually quite fact specific and isn't one people should put too much store by, or is that overstating it?
I think the legal principle isn't controversial, and I, for one, kind of as somebody who advises respondents daily on whistleblowing, was kind of pleased to see it because it's something which is really important. But I think it is very fact specific there, and I think I wouldn't say that is license for you to act as they did, and I wouldn't necessarily recommend kind of that. It's always the case, even if you are taking action with a whistleblower for completely different reasons, make sure you follow a set process, follow your internal processes, making sure you've documented reasons and you kind of back things up. So it's controversial in that you can see why a different tribunal might have decided otherwise, but I think the legal principles are sound.
Yeah. Okay, great. Well, I think that brings us to the end of our 40 minutes, so we can't squeeze any more in. But as I say, if we haven't got back to you on yours, then we will follow up after the webinar, so it won't go unanswered. So we will be circulating afterwards the feedback questionnaire by email. As I said, if you could take a couple of minutes to fill that in and send it back to us, we will use that when we're looking at the content for future webinars. We'll be doing a roundup in the mid-year, June, July, but we also look at those to see if there's sort of specific topics people might want to webinar on in between. So I will say thank you very much to Simon, and well done for your voice holding out. And thank you very much to all of you for joining. Hopefully we'll see you again on Thursday, same time, for our next webinar in the series, which is on the menopause. But otherwise, I hope you have a good rest of the day. Thank you.